When Alexander Murdaugh, who had been convicted of murdering both his wife and his son Paul, filed a motion for a new trial, claiming that the court clerk had tampered with the jury, that was considered a bombshell. Well, now the South Carolina Attorney General is striking back in their own motion, contesting everything. What are they saying?
Yeah, we were all surprised when Murdaugh's attorneys claimed that there was jury tampering going on. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today, the state strikes back at Murdaugh. Andrew, what is going on in the case?
Well, as you'll remember, the Murdaugh case has been something else from start to finish, and we're nowhere near finished, even though Mr. Murdaugh was convicted back in March of 2023 of first-degree murder in the deaths of both his wife, Maggie, and his son, Paul. And as I know you also remember, back towards the end of the summer, there was a real, and I hate to use the word bombshell. I really do. I don't like these, this is a bombshell. But anyhow, the defense attorneys, Harpootlian and Griffin, stood outside the courthouse and said that the court clerk had tampered with the jury and she was too busy getting ready to write a book. And it was incredible, the things that they said. And I don't like to overstate the case, but a lot of observers said that they had never, ever seen anything like that. And we covered that in a previous podcast. But just now, the state attorney general has spent a lot of time doing affidavits and talking to the jurors. And they have filed a lengthy motion in response and basically saying that what Murdaugh and his attorneys have said is totally wrong. So in a second, let's take a look at the affidavit itself. But what are your initial thoughts about that?
It's interesting to hear that they're just being completely struck down. I think that there was obviously a lot of mixed emotions with everything. And it was a little bit strange that, books were being written before the case was even done. But I'm not too surprised that the state is holding this stance, but I don't know. It's a little interesting.
So here's the actual motion that has been filed just now in the court in South Carolina. This is to show you that this is the legal pleading. It's the state of South Carolina versus Richard Alexander Murdaugh, just basically saying a little bit of the history. And we'll go to some of the meat here. And it says that not every inappropriate comment by a member of the court staff to a juror rises to the level of constitutional error. And as you'll remember, that was the crux of the whole thing, which we're going to get into in depth in a minute, that the court clerk had basically talked to the jury and tainted the jury pool and that kind of thing. Well, here, this page and the next page cite law standing for the principle. Basically, just because a member of the court might have said something inappropriate does not necessarily mean that we throw the whole verdict out. So they go on with the law and on with a statement of the facts in this case. Here, certain statements attributed to Clerk Hill, Rebecca Hill, by Juror 630 closely remember statements made in court by the state. And pertinently, you're going to hear, this is what the state had actually said. The parties made their opening statements Wednesday, January 25th. The state, as part of its own opening statements, advised the jury, you're going to hear 3 recorded statements on video that he gave with law enforcement. And you're going to hear how things progressed about what he says and what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right, or does something seem a little off? Does something seem a little off about this? And what's significant about this is that what Griffin and Harpootlian had said was that the court clerk, Rebecca Hill, had, said to the jury, watch out, you listen closely to what Murdaugh says when he gets on the stand. And so what I guess the attorney general is trying to say here is that well, that's what we said in our opening statement. Now, I don't buy that that's the same thing, because that's the Attorney General's job. That was Clayton Powers' job, was to take a position and tell the jury, listen carefully. So I don't necessarily buy what they're saying here, but let's follow along. And also, they say that at the end of their initial closing argument, the state implored the jury not to, they didn't just tell them, they implored the jury to not let Murdaugh. So, they use all this flowery language. Okay, so then the next heading in this pleading that was filed by the state of South Carolina, the court thoroughly investigated allegations of improper communications by juror 785 and ultimately dismissed the juror for those communications, but gave no weight to the supposed Facebook post reported to the clerk of court, Clerk Hill, in a conversation which was placed on the record. Do you remember the egg lady? Well, this was the egg lady that, was bounced off the jury allegedly for talking to her ex-husband and talking by Facebook. Well, what the state is saying, that really was, those allegations, really had nothing to do with the reason she was bounced off. As you will see in page 12, March 1st, 2023, the 27th day of trial, there were tenants that met with the Assistant District Attorney David Fernandez and Assistant Attorney Donald Zelenka, and executed affidavits consistent with their statements to law enforcement the night before, which stated that juror 785 had delivered a refrigerator to them on Saturday, February 18th, and briefly discussed the case. So one of the jurors apparently delivered a refrigerator, and there was a discussion. So that, I guess they're admitting that there were some discussions by one of the jurors.
I'm sorry, maybe, and maybe this is answering some questions for some people at home who might be as confused as I am, because it's saying that the Facebook post had no weight and that delivering the fridge and having that conversation. Are you allowed to talk about the case at all when you're not in that kind of court scenario? Like, are you able to talk to other people?
No.
Okay.
No, you're really not supposed to. And the judge repeatedly gives instructions that they're not to discuss these things. But the state then said that the affidavits and the motions that Mr. Murdaugh's attorneys had filed were wrong on those points and a lot of other points. So the state of South Carolina herein is doing a motion to strike. In support of his motion, Murdaugh provided affidavits, and we're going to get into the affidavits, and I think they'll answer your questions. Murdaugh had provided various affidavits which are deficient under the South Carolina rules of evidence. Notwithstanding any effort by the state to grapple with the affidavits in its arguments in sections 4 and 5 below, the state must respectfully move to strike portions of Murdaugh's motion for a new trial as follows. The state moves to strike as inadmissible hearsay the affidavits of a paralegal, Holly Miller. And so apparently Holly Miller is a paralegal for the defense attorneys. And one of the affidavits was not necessarily by the witnesses themselves or the jurors themselves. It was by this by this paralegal. In support of his motion, Murdaugh provides two affidavits from counsel Harpootlian's paralegal Holly Miller, which largely purport to reflect statements made to or otherwise in her presence by two jurors, juror 741 and juror 326. So here they state the law, and this is evidence 101 from law school. Hearsay is a statement other than one made by the declarant while testifying at the trial of hearing, offered in evidence to prove the truth of the matter asserted. So that's legal mumbo jumbo for hearsay is an out-of-court statement generally, right? Wait, you don't have to go to law school to understand that, right? Okay. An affidavit from Miller is not tantamount to an affidavit from the jurors themselves and constitutes textbook hearsay. Accordingly, the state moves to strike in part as inadmissible hearsay motion for a new trial. In support of the motion, Murdaugh had provided 4 affidavits which purport to reflect statements made by jurors, which in part pertain only to juror mental processes and interactions with one another. As previously noted, jurors may neither, and this answers your question, I think, as previously noted, jurors may neither testify nor may the court accept affidavits which pertain to any matter or statement occurring during the course of the jury's deliberation or to the effect of anything upon that or another juror's mind or emotions, accepting claims of outside or undue influence or extraneous outside information. Remarks in the affidavits regarding jurors' thoughts about the evidence or one another are not properly admissible or even relevant to the ultimate claim that's raised. So what they're saying is that, the affidavits that were submitted by Murdaugh's attorneys, Harpootlian and Griffin, first of all, they were improper. And second of all, they are based on hearsay. And third of all, as we're going to see in a little while, they don't necessarily reflect what happened with the jurors. And again, I don't like the word bombshell, but something that's important here, and we're going to get into it in a little while, is that there are actual affidavits and statements by the jurors here, not just 1 or 2 jurors, but a whole bunch of the jurors. So that's the real meat of what is important and what the state of South Carolina's attorneys have posted here. The greater part of Murdaugh's motion is dedicated to an outlandish theory that Clerk Hill deliberately fabricated the existence of a Facebook post implicating juror 785 in order to get them removed from the jury to force an outcome and thereby profit from fame and fortune. To be clear, in an attached affidavit, Clerk Hill affirms that she made no such deliberate fabrication, and she denies fabricating any Facebook post. Whatever Murdaugh's motivation, the court expressly did not rely on the alleged Facebook posts in removing that juror. Therefore, whether or not Clerk Hill saw the alleged post is mistaken as to the alleged post or even fabricated it is of no consequence to the validity of Murdaugh's conviction or the actual claim raised by Murdaugh of improper external influence upon the jury. Accordingly, the state moves to strike entirely the motion for a new trial and the exhibits, and moves to strike in part the motion for a new trial exhibit. So what they're saying here is this whole thing about the Facebook post really wasn't, and we didn't know this because this was all based on a conversation that was held in the judge's chambers. This was all discussed in the judge's chambers, all that happened on that day. I believe they said it was day 27 of the trial. There was a delay in the start of the trial that day. And we're all, people were sitting around watching it on YouTube. We're sitting there waiting and waiting and waiting. And then the judge came out and said that he'd had a conversation with one of the jurors and decided that she would be removed. So what they're saying is it was not based on this Facebook post, which now Harpootlian and Griffin are saying was made up. So what the state is saying is that's not even what the removal was based on.
Mm-hmm.
Now, this was the egg lady. This was after she was removed. And I know we got comments the last time that this isn't funny. How, on such a serious matter, why are you joking? Well, all right.
Who brings eggs to court?
Really?
I'll joke about that.
I mean, give us a break, okay?
One of the comments, one of the comments was like talking about like the financial situation or whatever of the eggs. It's just like, if you have chickens, like shout out, like I'm sorry, like the $3 egg carton is just weird. It's not a life or death situation. Like,
and you have to admit that it was unusual. And actually in trials that I've watched, some of them on YouTube, some of them in the courtroom in a very serious court matter, occasionally there are moments of humor and it breaks the tension. And yes, even the judge will have a little ha-ha on his face. So no apology for a little laughter here and there. Okay. So now we'll be serious. So what they're saying now, the Attorney General for the state of South Carolina, although Murdaugh's motion for a new trial makes various allegations as part of its attempt to craft a breathtaking conspiracy narrative, it ultimately boils down to a single constitutional allegation. Clerk Hill told jurors not to believe the defendant, thereby violating his right to an impartial jury, which, if true, that's a problem. But accordingly, even if the state assumes ad arguendo, and what that means is just for the purpose of argument, let's assume that they were right, that all of the competent elements of the affidavits provided are earnestly given, the relevant analysis is as demonstrated by the questioning in State v. Green. 4 elements that would have to be proven by the attorneys for Mr. Murdaugh. 1, was it the juror's verdict guilty? Was the juror's verdict guilty? 2, was the juror's verdict based on the evidence presented? 3, was the juror's verdict influence the alleged outside communication? 4, did the juror have any communications about the case outside of deliberations with the jury? All of the other details are irrelevant window dressing. So what the prosecutors in South Carolina are saying is, these are the only 4 elements that have to be proven in order to either keep the verdict intact or set it aside. Only one juror who participated in deliberations, juror number 630, ties to Clerk Hill any statements remotely consistent with Murdaugh's allegation of improper external influence. Quote, not to be fooled, watch him closely, look at his actions, and look at his movements. But even assuming for the sake of argument that juror 630's recollection is accurate and that he or she are not misremembering arguments expressly made by the state, juror 630 does not attribute their verdict to the statement of Clerk Hill, but rather, and this is interesting, avers that he or she voted guilty despite some questions, quote, because juror 630 felt pressured by the other jurors. The juror felt pressured by other jurors is not a valid basis to impeach a verdict.
That's a little weird. That whole thing is a little bit weird.
Well, yeah, and you got to go back to a movie that came out a million years ago, 12 Angry Men. I don't know if you saw it, but it's about what happens in a jury room. And my great-grandfather was a legislator, and he wasn't the first person to say this, but there's 2 things you don't want to see made, sausage and law in Washington, D.C., and I think jury verdicts are the 3rd thing. Because, no, it's not a pretty picture if one juror feels that they are pressured into it, but, a juror can always hold out. A juror can always say, no, you 11 people are wrong. And it does happen. We've read in the newspapers and I've followed cases for years where one juror can fall out. So there's actually case law, and this brief cites South Carolina law, but I will tell you that this is law in the jurisdictions in which I'm familiar, that the fact that one juror feels pressured by the other jurors is not a valid basis to impeach a verdict. And there's the case. So I agree with you. It's a little bit, but due process is not implicated where other jurors verbally abused a holdout juror for at least 4 hours. There's the case. So I kind of agree with you. It doesn't really feel good, but you know what? Passing laws, making sausage, and getting into a jury verdict aren't necessarily a feel-good kind of a thing. Remember that at the end of the Murdaugh case, in most cases, the jury is polled. There was a case in Florida just the other day where the jury was polled. All 12 members were individually asked, juror 1, is this your verdict? Yes. Juror 2, is this your verdict? So if you were really pressured, and I've never been a juror, I've known people that were, if you really feel pressure when the court polls all 12 of the jury, that's your chance, So, all right.
The whole thing is weird, especially with like the Facebook post and the fridge delivery thing. Ultimately, I'm not surprised the state struck back at this, but it's also, I don't know, like you said, it's not a feel good thing. So the pressure doesn't necessarily mean anything. And like you said, they had their opportunity to say something. So I guess it makes sense, but interesting.
Okay. So Murdaugh offers an affidavit which purports to represent statements made by juror 3216, although the affidavit is that of counsel Harpootlian's paralegal, Holly Miller. So it wasn't the direct word of the actual juror. It was the paralegal purportedly hearing what the juror said and then writing it down into an affidavit.
Oh, okay.
That is hearsay. for which I don't know an exception. Even if the state accepts, for the sake of argument, ad arguendo, that Miller's affidavit is the equivalent of an affidavit from Juror 326 themselves, it is unavailing to Murdaugh. Juror 326 contradicts Juror 630 and recalled no such comments by Clerk Hill regarding Murdaugh's credibility. What Juror 326 did recall was a warning that the jurors would witness disturbing images, which is a neutral trigger warning and not one which puts a thumb on the scales of justice. To be sure, the jurors did review disturbing images. So that's not something that's going to turn the case around just because somebody said, pay attention. You're going to hear things, and as I always say, the real meat in a lot of these things is down in the footnotes. So footnote number 10, a hearsay affidavit is still hearsay and is not competent evidence. So just because you dress something up with, you have a notary public sign it and you put their stamp on it and it looks all nice and pretty, that doesn't change the fact that it's an out-of-court statement. It's still hearsay. Then the next footnote, number 11, like Juror 326, the purported representations of Juror 741 are offered through Miller's hearsay and are not competent evidence. So what they're saying here is that the motion that was provided by Harpootlian and Griffin, it was, like some people said, it was a bombshell. But, if it's based on hearsay, remember, the real question here is, does this rise to the level where there's going to be an evidentiary hearing? I'm not the judge. I'm not a judge. But my educated guess is that there's going to have to be an evidentiary hearing to get to the bottom of all this. And maybe they'll bring in the paralegal Holly and we'll get to see what she really had to say. So the next argument by the state, in the alternative, in the event that the court concludes Murdaugh has made a showing sufficient to necessitate an evidentiary hearing in this matter, what were we just talking about? The state expects that sworn testimony to the court will prove the allegations to be unfounded and not credible. So now South Carolina law enforcement, which Harpootlian and Griffin did not want to do the investigation, but who else is going to do it? The SLED, it's known as, did poll the jurors, and they went back and talked to all the jurors. So you see in the left column, did you hear remarks on evidence by Clerk Hill? Juror 193, no. Juror 254, watch Murdaugh's body language. Juror 326, no. Graphic material warning only. So there's a difference between saying, the guy's a bum and there's going to be graphic material. Juror 530, no. Column 2, did you see one-on-one chats by the Clerk Hill with jurors? No, no, yes. Saw a chat regarding a financial and child support issue, and no. And then column 3, do you have any other concerns? And these jurors said, if anything, people were overly cautious. No, no, no. So far, so good. That's the first 4 jurors. And then here the others. And again, without going through every single one of them, there was very little corroboration with what the defense had said. No, generally didn't hear any problems. No, didn't see any one-to-one conversations. Juror 729, yes. Had a chat regarding financial child support, saw a clerk chat with others. So that's totally unrelated. Is it great? No. But is it going to taint the jury? Does that really taint the jury?
Yeah.
So, all right.
Well, also, it's their job to talk with them about that kind of stuff, right?
It's what?
Aren't they supposed to be talking about that kind of stuff with them anyway, about the child support?
I don't know. I don't know. I mean, I've tried jury cases, and if I found out that jurors were actually getting financial legal advice from the court clerk, I'd scratch my head. But you know what? Does it taint the jury in accordance with the case law that's been provided by the state here? No, I don't think so. So in response to the bombshell allegations by the defense, The prosecution in South Carolina, in my view, has met its burden to provide enough evidence to at least call for an evidentiary hearing. Whether that happens, stay tuned. Juror 785, purportedly the landlord to Juror 630, was removed from the jury after the court determined he or she improperly conversed about the case with other tenants during the trial, in contravention of the court's dozens of admonitions not to do so.
Oh my God, why these people?
But that juror was removed.
Good, but like,
Yeah.
I feel like it comes to a point where they just want to be removed. It's like they're talking about it because they don't want to be doing it. Because how else are you going around and chit chatting about this stuff that you've been told a dozen times not to talk about? Oh my God.
Well, you're right. They are told many, many, many times every day, at the beginning of the day, at the end of the day, don't discuss this. Don't even discuss it with the jurors. Talk about the weather, the sports team, whatever. But do you think it's that they want to be removed, like you said, or do you think it's just human nature? It's just human nature, don't you think? Maybe
It's like tenants plural. It's like I think like I don't know. Obviously, like humans want to talk to other humans, and especially when you're going through something like this and seeing all this graphic imagery, and it's like kind of crazy. I think that it's human nature to want to talk, but like you also know it's supposed to be your job to not talk, but like also people don't do their job all the time. So I don't know.
despite the fact that nowadays there's cameras everywhere, where there's microphones everywhere, there's I generally think that we're pretty much watched everywhere. I think that people generally tend to feel like they can be in private, when they're with their friends. We just all have a feeling of privacy when we're just with our friends, and so that's my feeling. I don't know. So we get to the crux of the matter on page 24. That's why we have two different colors of highlighter. Juror 741 told the law enforcement investigators that Clerk Hill told the jurors that the defense is about to do their side, and don't let them confuse or convince you. They may say things to confuse you. However, neither juror 630 nor juror 785 clearly corroborate that recollection, and no other juror even comes close to doing so. Juror 741 told SLED that she was aware that Clerk Hill wrote critically of her attentiveness during the trial, and additionally noted that Clerk Hill told her after the trial that no members of the media wished to speak with her. So where juror 741 may have, told the defense attorneys, that the court clerk said certain things, that wasn't corroborated by the other jurors. So now we get into an issue of real credibility. Are the statements that were made by certain jurors to Harpootlian and Griffin, were those credible? And remember, in every court case, every single statement is subject to scrutiny on the basis of credibility. So the greater weight of anticipated juror and court staff testimony is that Clerk Hill made no materially improper comments. The state denies Murdaugh is entitled to relief and anticipates that any evidentiary hearing will only reaffirm the validity of his conviction for the murders of Maggie and Paul Murdaugh. So they're basically saying, you know what, guys? No, this is smoke, and there's no fire under the smoke. You came out with these bombshell allegations, which most legal observers have never seen anything like it before, and there's a reason for that. It didn't happen. That's what they're saying. But there's more. Furthermore, there I go laughing and making light of the situation.
Oh my goodness, criminal behavior right there. Absolutely criminal. How could you guys be laughing? It's like, I'll laugh when I'm surprised at something or shocked that something happened. It's just like, why is she laughing? I'm sorry. I'm not sorry, actually.
Comment. We'll try to be more serious.
I won't.
Furthermore, even if Clerk Hill made any improper comments to the jury, the state has found no juror who will aver that anything Clerk Hill said or did influenced their verdict. That's really important. The clerk clearly instructed the jurors to consider only the competent evidence presented to them and to apply the law as the court gave it to them. The jury presumptively and affirmatively did so. Each individual juror reaffirmed their verdict when polled by the court, and none reported any influence from the court staff. So here's where your concern, which was that I believe you were worried that somebody felt that they were pressured, and that's not right. But, months and months and months went by from the early March conviction until this investigation, I believe, was done in October. So what's that? 7 months. They had 7 months to think about it. And if they've really felt that they were pressured into, finding him guilty when in their heart of hearts, they thought he was innocent, they could have told the investigators, but they didn't.
Mm-hmm.
So that's important. The court's instructions to consider only the competent evidence and individual polling procedure after the verdict was returned served to disabuse jurors of any misconceptions which may have developed over the weeks-long trial and cure any errors which may have otherwise resulted. So the conclusion is that wherefore the state of South Carolina respectfully requests that this court summarily deny Murdaugh's motion for a new trial, or barring that, convene an evidentiary hearing consistent with that conducted in the case they'd cited before. And upon hearing the testimony of the jurors and witnesses presented, find that Murdaugh's allegations to be not credible and deny his motion for a new trial. So now we jump down to the affidavit. Her name, apparently, we all thought was Rebecca Hill. Now we learn her name is Mary Rebecca Hill. And this is her affidavit in which she tells us, the window dressing up top. This is my affidavit. I'm telling the truth. I'm sworn to tell the truth. I'm over 18. There are numerous misrepresentations and false statements. Well, of course, you would expect her to say this, wouldn't you?
Mm-hmm.
But she's saying that the numerous misrepresentations and false statements contained within the motion for a new trial, to which she was not requested to specifically address. As such, this affidavit is not intended to address every allegation contained within the motion for a new trial. So what she's saying here is, I'm going to tell you what I was asked to respond to, but there's a lot more, people. There's a lot more. So she admits that she was the elected clerk of court for Colleton County during the case of State versus Murdaugh. She says, number 6, I have reviewed Mr. Murdaugh's motion for a new trial filed on October 27th. 7, as to the allegations contained within the affidavit of Juror 630, A, I did not tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys. B, I did not instruct the jury to watch them closely. C, I did not instruct the jury to look at his actions. D, I did not instruct the jury to look at his movements. E, I did not say to the jury, this shouldn't take us long. F, when juror 826 asked to speak with me, the conversations took place in the jury room hall within earshot of bailiff Bill Pohl. The conversations did not involve the evidence, witnesses, or substance of the trial. We're not going to go over all of them, but 8A I thought was kind of interesting. I did not have private conversations with juror 826 in the bathroom. That was one of the allegations you'll remember, was that she went into the bathroom and had some conversations.
That's like a bold claim to make, because I don't know, I don't know how much all this matters, but I'm assuming these two people are of the same gender, that there is a chance that they could go into the bathroom together and have a conversation. I don't know. I think, to say it's private, I think would imply that they wouldn't want other people to hear it. But out of everything, I mean, I love this. It's like, I did not do this, I did not do this, and I did not do this. I think, it's nice to see it all clearly stated and whatever, but that's just interesting. I feel like for me, because I'm someone who's like, I do a million things that I forget. I don't know if I could ever confidently say I did not talk to this person in the bathroom, but just interesting.
Yeah. So I don't honestly know how much faith I hold in this affidavit, because her job's on the line, her credibility's on the line. But they talked to jurors too. And we're going to get to that in 1 second.
Ooh.
But there's more.
But there's more.
The only other interesting thing I found here was that she said, I did not tell jurors they were prohibited from taking a smoke break during deliberations. Now, you remember that was one of the things that was alleged by the defense counsel, Harpootlian and Griffin. They said This court clerk was in such a hurry to push the jury, she told the smokers, you can't have a butt until you get a jury. If true, first of all, I'm a rabid anti-smoker, so I have no sympathy to smokers. But, in a context like this, I have to open my mind, which is rare, of course. Have to open my mind and realize people are smokers. They should be given a break. And in this context, that would have been wrong. I don't think it would be grounds to overturn a jury verdict, but who am I to decide South Carolina law? All right. So what is really interesting, I think, as you pointed out, she says she didn't do it. She didn't do it. She didn't do it. All right. If you ask a little kid, are you the one that put your handprints all over the wall? I didn't do it. I didn't do it. I didn't do it. But these are statements of jurors, and they're kind of hard to read. And in the scanning process, in that they are handwritten, they're kind of hard to read. But I found a couple here. Juror 572. Right here, juror 572. This is one of the actual jurors, and they, redact their name, because if you serve on a jury, you have a right to absolute privacy and confidentiality. So they redacted this juror's name. It's juror 572. They were interviewed by Agent Tiffany Tortorello, I believe that says. Am I right about that?
Oh, looks like it.
Okay. So this is a juror, and this is way after the trial, and it says, no, I was not coerced to give any answers. My decision was of my own. No court employee influenced my decision. I did not have any private conversation other than myself talking to Mrs. Becky Hill about me not using the stairs because of my knee injury. I did not witness any private conversations amongst the other jurors. I did not hear any witness or any court official saying to the jurors that we should not listen to the witnesses or shouldn't take long. No one made me feel that I had to arrive to a quick verdict, and if I didn't, I or the jurors would not be able to leave. No one from the defense team ever reached out to me during the Murdaugh trial. The juror that was ejected from the trial stated one morning on the van that her husband told her we were going to Moselle, and we told her no discussions. So I find that interesting. I mean, and this is the kind of thing you want a court clerk to say, geez, if you have a knee injury, don't use the stairs. We'll make a provision for you. The elevator's over there. That's the kind of thing that you expect a court clerk to be doing. And she's obviously saying, where one juror did speak up, we're going to Moselle. Well, we can't discuss it, talk about the weather, talk about whatever. So that's interesting. Then there's one more jury statement that did come through. Again, see how
Beautiful.
hard they are to read? Yeah, some of them are really hard to read, but they are reprinted elsewhere, and they go along pretty much the same lines. There's no, bombshells in here. This is juror number 826, interviewed by a state of South Carolina law enforcement agent. Question, did you feel pressured at any point during the trial to make a decision? No. Did any court official or court employee pressure you or any other juror or another as it pertains to guilt or innocence? No. Did any court official or court employee have a one-on-one conversation with you or any of the jurors? No. Did anyone attempt to contact you after the trial regarding the trial? No, except the media. Did you see anything during the trial that you perceived to be inappropriate or unethical? No, not that I recall. So the state of South Carolina went ahead and they interviewed the jurors, and those are the ones that we can read. Some of them are just, you can't really read them, but I don't know. I've read what the defense attorneys said, and now I've read most of what the state has said, and I guess there's enough for I guess there's enough for an evidentiary hearing, but I don't know. What's your take on all of this?
It gives me a headache. Oh my god, it's so messy, but you know, it's hard. I'm not a court, I'm not a legal official. I even though I'm Lainey law. So it's like there's a lot of elements to it that I don't fully understand, but I also like because even though like certain things like the delivering of the fridge or the Facebook posts and things like that, telling your tenants is really weird and good that they got kicked off. Overall, I think the thing is court I imagine is just so expensive too, so to go through all of this again, and it sounds like the jury from their affidavits don't believe that anything that they were tampered with. So, I don't know, it's messy, but I can see why it's going the way that it is.
It just was so unusual. I was sitting at my desk one day, just doing some legal work, going through my files and doing what you do as an attorney. And I got a little alert that something was going on. So I went on to YouTube live. I don't know what channel, but someone somewhere was, I think it was one of the TV stations down in South Carolina that also broadcasts onto YouTube. And I turned it on, and there were the two attorneys for the defense, attorney Harpootlian and attorney Griffin, who, they've been practicing law down in South Carolina for many, many, many years. They're, well respected. Say what you will about the fact that they tried the case the way they did, or that they represented Murdaugh to begin with. But
Mhm.
there they were standing in front of a courthouse, talking about how the court clerk had tainted the jury and talked to the jury and pressured them and told them, you can't smoke. You can't have you can't have a smoke until you find a verdict. Take a really good look at Murdaugh. Be careful of what he says. And the way they presented it all made a lot of people say, wow, if all of this is true, there might need to be a new trial. But now we're seeing the state say, wait a minute, we don't think it's true. We did do an investigation. What the defense attorneys are going to say is, oh, well, the SLED has a conflict of interest. The South Carolina Law Enforcement Division, or SLED, has a conflict of interest because they were the ones that were doing the investigation to nail Murdaugh, to put it bluntly. And so they have an interest in, not having to retry the case. And so they shouldn't have been the ones that invest. That's what Griffin and Harpootlian are going to say. They had specifically said, we think the FBI or some outside agencies should be called in to investigate our allegations. Well, that didn't happen. And whether there's any kind of requirement that happen, I don't know. Obviously not. So this is not going away. Murdaugh is the fourth in a generation of very powerful attorneys. I don't know how much money he would have left. I mean, he embezzled so much money, and he has admitted it. So you can put anything you want down in the comments, but I'm not saying anything that's not of record in a court where he has admitted financial wrongdoing. So, this could go on for a long, long, long time,
I can't even imagine. I hope, like I mentioned before, that I think court is something that's really expensive and consumes a lot of resources. So, obviously the court has made its decision, and I hope that things can just proceed and that these people can move on with their lives. But like you mentioned, is like he's a man with a lot of power, potentially some money left. We don't really know that. It will be interesting to see where this goes, if it continues on or if finally, we put the nail in the coffin and we can ship it away.
Yep. Nope, you're right. And this is an issue that's going to continue for a long time, is my guess. So we'll move along. We'll get back to you on this case as things develop. We have gotten a lot of comments, and thank you very much for watching us, sharing us, viewing us, and commenting. We've gotten a lot of comments, and we hope you will still do that. Do you have any closing thoughts, Lainey?
No, I mean, on that same note, thank you everybody for all the good things, bad things, all the discussions that happen. At the time that we're filming this, we have, I believe, 857 subscribers, which is insane. The amount of support that we've gotten in the past month has been awesome, and I'm super grateful to see that a lot of you guys are enjoying the content, and it really, makes my day. And some of you guys, it's all really awesome to see the passion and the interest and all the different opinions. So thank you guys so much for all your opinions and all your support.
The day will come when we'll look back and say, we were excited over 800. Anyhow, thanks a lot. Please remember to subscribe and view and share with your friends. And as I always say, your enemies too. So have a good day. Thank you. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.